Once again, welcome for our, I think this is our third series of the Family Rounds, sponsored by the Hope Network Center for Autism. We want to thank Dr. Krishnan, who's the director of the center, for hosting this and allowing us to use the facilities. And tonight's topic is one that's all near and dear to our hearts, is, God, how does the system work? How do we navigate through the system? We're fortunate tonight to have Dan Blau, who's a well-known attorney in the area that specializes in the area of disabilities and a whole array of topics that I'll get into shortly. And his associate, Sarah Kirkpatrick, is also here tonight, and I think they're going to tag team, as Dan says. So, a couple things. We're going to hold questions to the end, if we could, just from my experience, because of the topic, particularly Dan's going to be covering. We're going to be itching to answer a lot of questions, but we're going to wait to the end. It's about a 45-minute presentation, and Dan and Sarah will be here afterwards to handle some individual questions for you and perhaps help you with some of your needs. So with that being said, I'm going to turn this over to Dan Blau. Thank you, Dan.
Thanks, Doug. If I speak at about this level, is it okay? Can you hear me? I'm going to try to keep it quite informal, even though we're going to leave questions for the end, and try to cover some of the big three legal issues that affect families when they have kids with disabilities or autism. I'd be interested in knowing how many of you have kids that are under age 18 with disabilities, and how many of you have kids over 18, the rest. And is it autism in almost every case? Are there other types of disabilities represented here? We'll focus in on autism, I think, but we do a lot of work with all kinds of disabilities. My background is a little different. I've been a lawyer for quite a while, since 1980, but I didn't do private practice the whole time. I worked for nonprofit organizations like Hope Network. So out of law school, I first worked at Legal Aid, where I got to learn about SSI and other appeals that you have. And then I worked as the director of the ARC here in Grand Rapids, which is the association. They used to call it the Association for Retarded Citizens. Now it's just the ARC, handling all types of developmental disability. And then I got to know Jim Toonstra, who was the director, the chief CEO of Hope Network, and we got a contract to work on housing for people with disabilities. And I worked for Hope Network for 8 years, trying to develop supportive housing for people with disabilities. And that could be all kinds of home ownership, or condos, or rental, or parent-owned homes, or all kinds of creative ways to get the right supportive living for people with different kinds of impairments. And we created quite a few options all over Michigan under that project. That was funded by the Kellogg Foundation. Well, the Kellogg Foundation ran out, and the mental health system really wasn't ready to jump on it and fund that kind of effort. So I could see the writing on the wall. So in 1999, I hung out my shingle and went back into private practice to do disability law. And when I say disability law, my experience, I've represented more than 1,400 families in the last 10 years. It's probably an average of about 140 new families a year that are almost all in the same boat. They have a child with lifelong disabilities. They want to make sure that they plan correctly for maximizing what they can get from government benefits, but also using the private funds that they might have in order to augment the government benefits in such a way that they don't jeopardize the Medicaid, but they can augment it to increase the quality of life for their own son or daughter. So we work with a lot of families in that boat. And the big three issues that we deal with are public benefits, how you can deal with private funds through such a thing as a special needs trust, and then another issue that comes up in so many cases is, do you have to become guardian of your own son or daughter once they're over age 18? Those are very common legal issues. So I'm going to start out and talk about some of the public benefits issues, and then Sarah's going to kind of tag team it and talk about some of the special needs trust issues, and then we're going to probably leave just a short amount of time near the end to talk about guardianship issues, and we can answer more specific questions near the end if we need to. But those are the issues. So, as you know, and those of you with younger kids, you know that special ed is a form of public benefit that's very valuable. It gives you a lot of services while the child can potentially be up to age 26. And there's also other kinds of benefits when the child is young. There could be children's SSI benefits from the Social Security Administration if the family is low income. And there could be children's special health care benefits while the child is young, especially if there's a lot of physical disability along with the cognitive or mental health issues. And then there's other types of smaller programs. One of them is called a family support subsidy that some families get if their income is relatively modest and they have a severely impaired child. They can get family support subsidy from the state of Michigan. But the benefits that are the most families really start to hit the public benefit system is when their child is getting close to age 18 and they need to apply through the Social Security Administration for benefits. And as you know, Social Security runs two programs. They run Supplemental Security Income, SSI, disability, and they also run Social Security Disability Insurance, SSDI, disability. And those are both run from the same office. Our local office here in Grand Rapids is on Knapp now, near the cinemas, real close to the theater there. So you walk in the door, and if you don't know what you're supposed to apply for, but you say, I've got a severely impaired child, and I want to apply for benefits, they're supposed to help determine which benefit you're eligible for and treat it as an application for anything, and they direct it then to the part that is appropriate, SSI or SSDI. The thing that's rather maddening for a family or for attorneys like us is the SSI workers don't know anything about SSDI, and the SSDI workers don't know anything about SSI. They really stay in separate silos, and they don't describe the difference between those two programs very well. Well, what's the same about those two programs? Those two programs both have to have a severe disability, a medical impairment that's in their definition severe enough to get benefits. Not just any old disability is enough to get benefits, obviously. It has to be severe. How do they define severe? Well, the first thing they do is look at whether you're working right now at the time you're applying. Because if you're making money from a job and you're making more than this magic figure of what they call substantial gainful activity, then they're saying, we don't care what the doctors say, you're showing you can work. You're making more than SGA, substantial gainful activity. So Congress, in its infinite wisdom, has set the figure for what SGA is, substantial gainful activity. And this year, it's easy to remember because it's like tax forms. It's 1040, $1,040 a month gross. If you make more than that from a job, they're saying you're over SGA at the time of application, and it's not a severe enough impairment to get either one of those benefits, either the SSI or the SSDI. So that's the first question. But most of our folks, our loved ones are not making that much. They're not making more than SGA. So they have to go to the next step of what they call the sequential evaluation process, and they look at what the medical documents show and to see if it's severe enough. Now I'm going to do something that I do with a little bit of trepidation because I'm not very tech savvy, but I'm going to try to back out of this just for a minute and go to the actual website for Social Security. So if you go up here where my cursor is moving, ssa.gov, they've got a really simple website address, ssa.gov. And when you get to that part of their website, what I found is if you go to the search button over here, they've made this so much better in the last few years, and you type in listing of impairments, boom, there you are. There's part 3 is the listing of impairments, an overview of what that is. I won't click on that right now, but the guts of it, especially for somebody who's 18, who's an adult, is here under Part A. So you click on the Part A listing of impairments, and now they've got magic words in there of what they consider to be a severe enough impairment to start getting benefits. And the magic words are for every kind of impairment you can think of, musculoskeletal, cardiac. We're most interested in this part right down here called mental disorders. Their wording is a little archaic at times, but you play by those rules. When you get to every kind of impairment you can think of that's under their category of mental impairments, when you get down to 12.10, you see autistic disorders and other pervasive developmental disorders. Click on that. Here's the magic words. Here's what you have to be able to show that it's a severe enough impairment to get SSI or Social Security. The medically documented findings are the following. And by the way, it's not just a bald assertion by your doctor or by Dr. Krishnan or somebody that just says, oh yeah, I think they're disabled. It's a discussion or an evaluation of the signs, symptoms, and laboratory findings that they have through their testing that shows that there is that level of impairment. And so what does the medical documentation have to show? For autistic disorder, it has to show all of the following. Qualitative deficits in reciprocal social interaction, qualitative deficits in verbal and nonverbal communication, marked restricted repertoire of activities. Am I describing your kids? Or for pervasive developmental disorders, there's other kinds of magic words that they use. So they have to show those things, and then, if I get down to it, you see the word and. You have to have all those things that show, that they have restricted repertoire of activities and that they don't do social interaction like a normal, typical person would do. But then you have to show that it results in at least two of the following. Marked restriction in activities of daily living, marked difficulties in maintaining social functioning, marked difficulties in maintaining concentration, persistence, and pace. There may be somebody who's really quite good at interacting, and they could learn to do a particular job, but there's just no way they're going to do it and concentrate on it for 8 hours. Or it could be that they're very good at concentrating on something that's like a piecework job or something that's repetitive that they like, and the concentration is no problem, but they can't work as fast as the average person, the pace or the persistence. So those are the kinds of magic words that you want in the psych reports if you want to get disability benefits from the Social Security Administration. And it's not like it's a secret. They're right here on the web for you to look at. But I'll give you an example of problems that come up. We just had a case this week where it's a young man who's still in school up in the North Rockford schools who got denied. He's got autism, and he goes to this thing called KCTC, the Kent Career and Training. And he got a temporary job placement at the Meijer, working with the carts in the parking lot. And so they got denied benefits. And we go to look at what was in the psych reports and what was in the reports from the school. And they were glowing about everything that this guy could do. It says he loves his job. He can do his job. He didn't miss a card. And it's not like he doesn't have an impairment. It's sometimes the teachers, in that case the psychologist and the social worker and the job coach, were so interested in building up his esteem that they were shooting him in the foot when it comes to getting benefits from SSI. And that's a problem. I mean, we have to be careful walking that fine line. We have to obviously be honest when we do these reports over what they can and can't do. But sometimes people will write a report that's too glowing, and then they're denied benefits, and then you have to wait 2 years for the appeal, and it's a real stress on the family and so forth. So I point that out just to kind of show you that there's a myth out there about Social Security that everybody has to apply once and get denied. Nobody ever gets it the first time. That's a myth. If you have a doctor's report that uses some of these magic words, honestly, they don't make them up when they don't apply. But if they can honestly use the nomenclature that's set out in the statute and the regulations, you can get approved on your first application. You don't have to get denied. and it's just a matter of getting it in place. That's what lawyers do. Now that, you know, I have this theory that with the internet, we're really not going to need lawyers in the future, because you can look these words up yourself and you can talk to your psychologists in schools and say, hey, this is what Social Security is looking for. Is it honest? I mean, could you honestly use some of these words? Not make it up, but do they fit? If they fit, use these words, you're going to get our son on benefits a lot faster. So what is the process for applying? At age 18, you go to the Social Security Administration, or you call up their national toll-free number, or you go online like they want you to do, which I've never had a whole lot of luck with, and you say, I've got a son with autism, and he really needs to apply for benefits, and here's the names of his psychologist, and his school psychologist, and his neuropsychologist, and his pediatrician, and his other disability doctors. And you actually give them your data about who has medical records. Then they'll send a letter to you to have your son or daughter sign a release form. They're 18. You can't really sign a form, but you can help them sign the release form. And this shows that then the Social Security has authority to send a form letter to those psychologists. They box them all up, send them back to Social Security. They scan them in. Goes to the Disability Determination Service in Kalamazoo. That's a bunch of doctors and nurses sitting around, psychologists, reading medical reports all day. Must be a fun job. But what they do is they're looking for these magic words when they read this documentation, and if it shows a severe enough impairment, then you're going to get benefits. And a lot of times it'll take 4, 5, 6 months between the time you start applying and the time you're approved. But then they will give you SSI back to the date of application of the SSI, and you get a retroactive check back to the beginning. That's for SSI. For people that have SSDI, I'm going to talk about the difference between those two, but it is a little slightly different thing. One of my famous examples for what's a severe enough impairment to get these. You got a son with autism. His IQ is relatively high. It's way over that bright line 70, which, you know, if somebody has an IQ below 70, then it's almost a sure thing they're going to get benefits. It's over 70, but it's autism, and of course on the spectrum, there can be people with Asperger's who have high IQs a lot higher than any of us in this room, and they still could have a severe enough impairment. And they're going to look at whether you're working right now and what the doctors say about your impairment, and they're going to blend all those factors together to determine whether it's severe enough. One of my famous examples is Christopher Reeve, Superman. He's on a feeding tube and a breathing. He's totally paralyzed, and he applies for Social Security disability and he's denied. Why would he be denied if he's on a totally quadriplegic, absolutely no movement, can only basically move his eyes, use a breathing tube? Because he was making too much money. He was making more than SGA. He was making all his royalties from his books and his appearances. So he showed a capacity of being able to make more than the limit and still get Social Security disability. So he wasn't severely impaired from their point of view. So it's not just a pure medical thing, it's a mixture of financial and medical. Well, let me try to skate back to our slides. And I think so this is a little summary of what I just said, what applies to both programs, SSI and SSDI. First, are they working? Are they suffering from a medically determinable impairment? All these things. You can read that on your own. That's a written summary of what we just covered. Now, let's talk a little bit more about the difference between SSI and SSDI. Most families, if the parents are middle class and they're working and they're not retired yet, and their son has a disability and they apply for benefits, the son is not going to be eligible for SSDI at the beginning. If they're going to be eligible for anything at the beginning, it's going to be SSI. Why is that? Because SSI is a program for people with low income and low assets who have not paid into the Social Security system yet. They haven't paid those FICA taxes out of any earnings from a job. They haven't had a job. They're just 18. They've had just maybe small little jobs through school or something. And so they're not going to be eligible for SSDI yet because they haven't paid into the system and they don't have a qualifying relative who's paid into the system. But they are eligible for SSI. So how much do you get from SSI? SSI, first of all, you have to be poor on paper to get SSI. Once you're over 18, they do not look at the parent's income or assets anymore when they figure out if the child is eligible for those benefits. But the child has to have less than $2,000 of countable assets in their own name. So they can't have, if they've got a savings bond sitting in the drawer that grandma gave them when they were born and they even forgot about it, and then they apply, they get to the point of being medically determined severe enough, and they go back into the Social Security office and start talking about their finances. That's what happens, by the way. First they find if you're medically severe enough, then they start asking you about the finances of the person to make sure they're eligible financially for SSI. And there's, oh, they ask you, is there any savings bonds? Oh yeah, grandma gave them a savings bond that was worth $1,500 when they were born. She gave it to all the grandkids. It's been sitting in the drawer for 18 years. How much is it worth now? $3,000. Oh, too rich to get SSI. We don't care what the doctors say anymore, even though you went through all that with the doctors. Now you're too rich to get SSI. So it's a financial aspect too. You have to have low income. Your income from earned income has to be less than the SSI rate. How much do you get on SSI? Well, if you're living on your own, or you're even living with your parent and paying your parent some rent, then you can get the full amount of SSI, which is $710 a month this year, $710 a month. The beauty of SSI, of course, and we're going to talk about this later, is that Medicaid goes with SSI. And the Medicaid is even more valuable than the SSI, and I'll tell you why in a little bit. But SSI is needs-based. You have to have less than $2,000 in the bank. You have to have low income. So most of our families are going to have that at the beginning, most of our young people when they apply. And they're going to be humming along maybe for quite a few years, just getting SSI. But then something happens that lets them jump over the line to the next program, which is SSDI. And that is, even if they didn't work much and didn't pay into the system, if they have a parent who's retired, disabled, or deceased, that's a triggering qualifying relative that will get them into the SSDI side of the world if they're a disabled adult child. So sometimes people will be humming along for quite a while on SSI, and then their first parent will retire, and now they can start getting SSDI based on the work record of that parent, which is usually a higher amount, a bigger check each month that comes to you, because the parent has paid into the system more than they, more than that rate that would have left it. Sometimes people will pay will have a small job and not pay very many FICA taxes into the system, or they have a parent who didn't have a very high-paying job and they paid just a small amount of FICA taxes. And then the person will get both benefits. You know, it used to be in the bad old days, if you switched to SSDI because your parent retired and you got less money than you would have gotten if you hadn't paid anything into the system on SSI, that's what happened. People were kind of out of luck. So now, I remember when they did this, remember Congressman Pickle, the Pickle Amendment said you can get both now. You're guaranteed to get at least the SSI rate plus $20 because of the strange calculation rule they have. So sometimes people will get two checks. They call it a concurrent claim, and they'll get an SSI check and an SSDI check. And it'll depend on the fact pattern. Now, are you confused yet? I mean, this is why when you talk to all these families that you know, everybody seems to have a different story of what they get. Do they get SSI? Do they get SSDI? How come do people on SSDI get different amounts? It's because it's based on what they paid into the system. It's more like insurance on SSDI. That's what they call it, Social Security Disability Insurance. But, and so everybody's got a different fact pattern, and it's complicated for people, so they give up and they say, it does make sense, it's just that there's too many moving parts for the average person to follow it. So there is no asset limit for SSDI. You can have $2,000. That savings bond can be worth $10 million, and you still get Social Security disability. You can be Jay Van Andel, and your son can get disability benefits. It's not a needs-based program on SSDI. But, here's the big but. Medicaid still is a needs-based program. And even people that are on SSDI, eventually if they switch to that side of the world, still need to play the game to stay on Medicaid. Well, why would you need to do that? Because Medicaid is the program that funds community mental health services, Network 180 services. And those are the adult services that so many of our people need. And so you really need to play the game and still keep assets below the $2,000 asset limit, even if you've switched to the SSDI side of the world, because you need the Medicaid that goes with it. And there's different forms of Medicaid that you can apply for. You know, when you're on SSI, it's automatic. They call it a categorical qualification. You automatically get full Medicaid if you have even $1 of SSI. But if you're over that limit, if you're not on SSI, but you're still relatively low income, there's different forms of Medicaid you can apply for separately from the Social Security Administration through the Department of Human Services to get you a Medicaid card, which you need in order to get community mental health services. So it's real important. I also put a note here, sometimes when people are waiting for their Social Security related benefits, they can apply to the state for a small state disability benefit that's meant to be a temporary benefit while they're waiting for the Social Security to get approved. So, in summary, SSI is based on need. The amount you get is based on your living arrangement. I didn't really cover this in much detail, but the moral of the story is if you have a son or daughter living with you, charge them some room and board because you get more SSI. And they're going to need it. Then once they pay that room and board to you, now it's your money. You can put it in a trust that we're going to talk about, or you can use it for the room and board, or you can do whatever you need to with it. But it's always best to try, at the point they start getting SSI, to start charging room and board to your own son or daughter. You may say, well, I would never do that. Well, just think the long term. If you do that and you get an extra $200 and some in your each month's check, what can you do with money like that? You could buy a life insurance policy that will pay off if you get hit by a bus with that money. I mean, the government is funding a life insurance policy. I worked with one family in McBain, Michigan, or near Cadillac, that they were getting the wrong amount of SSI for a long time because they were getting that reduced rate, living in the household of another rate because they weren't charging their own son or daughter's room and board. And as soon as we started charging them rent, and the SSI went up to 710. It actually wasn't 710 because it was a few years ago. These figures are key to cost of living. They go up every year almost. But once they had an extra $200 and some every month, they went to the life insurance guy and said, let's buy a second to die policy on the parents. So that if both parents got hit by a bus, then there'd be a life insurance death benefit that would pay off to a special needs trust for the benefit of the child. So even if they didn't have any other assets to leave their child, say it happened way too quick, when the child was 22 years old, that life insurance could pay for long-term amenities for their child, even if they had no other estate to leave, because they didn't have any other estate. So, there's a lot of creative things you can do with that money. If a person lives in foster care, in an adult foster care setting, they get more SSI. They get up to like 867. A small amount of that stays as a personal needs allowance for the person, but the rest goes to the foster care provider for the basic room and board at the foster care. I'm going to just cover something very briefly now, and it has to do with, okay, our kids, autism, yes, they've got some social interaction problems, but I've met many young people with autism on the spectrum who can do supportive employment if they find the right niche. And how is their work going to affect their benefits? the world is divided again between SSI and SSDI. On the SSI side of the world, it's almost like a teeter-totter. The first $85 you earn from your job, say you get a job at McDonald's, or my guy at the Myers parking lot who's doing carts, and he's making $285 a month from his job. How's that going to affect the SSI, the 710 that he's eligible for? Well, it used to be in the bad old days, every dollar you earned from your job, you lost a dollar out of your SSI check. There's no incentive to work at all. So the congressman finally realized that and said, no, we're going to make it a 2-for-1 setup. The first $85 you earn from your job does not affect your SSI at all per month. But after that, for every $2 you earn from your job, you're going to lose $1 out of your SSI check. And you have to report your earnings every single month because it goes up and down. If you have a 5-pay period month and you make more that month, you're going to get a smaller SSI check. Actually, it's 3-month retrospective budgeting so that change doesn't really hit till way down the line, so it messes a lot of people up. But that's what they do every month, is figure out the 2-for-1 set off if you're on SSI. So it's worth trying to work. You have more money in your pocket by working. You can't let your bank account add up to more than $2,000 though if you're working, because now you're too rich to get SSI, and no matter what you're making, you're off benefits. So be careful. Now, what about the SSDI side of the world? If say your dad has retired and you've switched to SSDI, and instead of getting $710 a month, you're getting something like $800 a month or $1,000 a month based on how much your father paid into the Social Security system. It's a different set of rules for SSDI. And basically, it looks really harsh at the beginning. It's kind of an all or nothing rule on SSDI. They don't really care about your finances, except they've got this concept of SGA, that if you're making too much money, that might be proof that you're not disabled at all anymore, and we're going to cut you off completely. So if you're on SSDI, same kid, the one that was on SSI all those years, now they're on SSDI, they just have to make sure that they keep their earnings below that magic figure of SGA, which this year is $1040 a month in gross earnings. If you keep your earnings below SGA while you're on SSDI, you're going to be found to still have a severe impairment, and you're going to still get your full SSI check. It's not a 2-for-1 set off when you're on SSI. It's either all or nothing. So some people, they inch up to those maximum hours that they can work to still stay under SGA, and then they stop working. And of course, Hope Network and Goodwill and all these agencies know those rules, so they keep people below SGA if they're on SSDI because they don't want them to lose all their benefits. There's more we can embroider on with this that's more than we really have time to go into tonight. But because that's a harsh rule for SSI, it's mitigated in a couple of ways. One is something called a trial work period, where you can make any amount for 9 months and still stay on your full Social Security check. And the other thing is when they recognize that people start to, what they call it work hardening, if they start getting more and more able to work and make close to SGA, they have extended periods that any month that your SGA, your earnings go below that magic figure of 1040, then you automatically get a full Social Security check without having to reapply. So that's called an extended period of eligibility. And even beyond that, say you've got a work history where you're making more than SGA consistently, and you've run out of your trial work period months, and you've run out of your extended period of eligibility months, then they have a thing called expedited reinstatement, where say somebody is bipolar, and they're doing fantastic, and then they decompensate and they can't work for 3 months, and their earnings plunge to 0. They'll let you do an expedited reinstatement right away without having to go through the full process. So there's ways that they try to mitigate against the harshness of that main rule. Well, that's a summary of Social Security, and I'm sure you have questions, but we'll deal with some of those, make a little note of them. But what we'd like to do as we're heading through the evening is talk about special needs trust. Remember the magic rule the most important rule is you cannot have more than $2,000 of countable assets in your own name and still get either SSI or, even more importantly, Medicaid. And Medicaid pays for mental health services, so you want to stay on Medicaid. And a way to stay on Medicaid and to deal with private family funds is this thing called a special needs trust. So it's almost a year ago today that Sarah joined me to work in this area, and she works part-time, and her husband works downtown, and she is dived in to get to know this stuff just as well or better than me. So she's going to talk about special needs trusts.
Well, thank you for having us. It's been a privilege to work with Dan for the last year. He has a great reputation in the community. And I graduated from law school several years ago. I spent over 5 years working for the Michigan Court of Appeals, and then decided I wanted to work part-time when my husband and I started having children. And Dan was finally ready to hire an associate, so it was great timing for me to come on board with him part-time. But I've known Dan for over 10 years now. First met him because I have an adult brother who's autistic, and my parents hired Dan to prepare their wills and special needs trusts for David's benefit. My brother's name is David. And David actually attends day programming here at Hope Network. He's already transitioned out of school and into the adult system. And so as a sister, I understand what a lot of your questions are. And, you know, I can understand the frustrations and your hopes and dreams that you have for your child, and just a lot of the questions that you might have. So I'm happy to chat with any of you afterwards, and so is Dan. But I'm going to talk a little bit about the special needs trust piece. That's a lot of what Dan and I do. We give advice to parents on public benefits, but a lot of the bread and butter work that we do is to create special needs trusts for families. And in general, a trust is a document, a set of rules on how to hold a pot of money, how to hold it, how to spend it. And a special needs trust really is the primary reason to do one is to shelter the money that's in a trust so that it's not counted when the government decides whether you have that $2,000 asset limit. So it's sheltered in such a way that it's not counted. And then you have that pot of money, that private money, to use over your son or daughter's lifetime to, as Dan said, augment the public benefits that you're getting to give them a higher quality of life. And there are specific rules that have to be in a special needs trust for them to count for Social Security, to say, yes, those assets are now exempt, we're not going to count them towards your asset limit. And some of those rules are that the trust funds have to be used for the sole benefit of the person who has the disability. That you can't use trust funds to take the whole family on vacation or something like that. The funds need to be used for that person's sole benefit. The trustee, the person that you choose to be in charge of that money, has to have sole absolute discretion over how the money is spent. The person with the disability can't be allowed to just reach in and grab cash, figuratively speaking, whenever they want to. They have to go through the trustee. The trustee has to pay for bills on their behalf rather than just handing them cash, because if they're handing them cash, Social Security and Medicaid is going to say, that's income to you, that's your asset. So there's specific rules that the trustee has to follow. And then another thing that all special needs trusts have in common is that you should use those funds for things that the government benefits don't cover. So you don't want to duplicate what the government's paying for, but anything else is fair game. It can, funds can be used on things like buying a new computer, or that the child's share of going on a vacation, or dental bills, let's say, that Medicaid doesn't cover, extra, services that aren't covered, companion to go with them for the baseball game, anything like that is fair game. So those are some things that all special needs trusts have in common. So when a parents come into our office and they say, we want to create a trust for our child, the first question that we ask them is, whose money is going into this trust? That's an important question. If you're starting out with a trust that mom and dad want to fund, or grandma and grandpa want to fund, somebody else like that wants to fund, then we're going to create what's called a third-party trust. Mom and dad are the third parties. But if your child, the person with the disability, already has their own money for some reason, they're already over that $2,000 limit, then we have to create a different kind of trust that we call a first-party trust. The child is the first party, whereas the parents are the third party. And there's two different kinds of first-party trusts, so you get to another division in the road, and I will describe to you the differences between those two. But we're going to start out by talking about third-party trusts, because that really is primarily what many of you might be looking at doing for your son or daughter. That's kind of on the third-party trust there on the left side of that column on your handout. But a lot of times we do that kind of trust as a part of mom and dad's estate planning. So they'll come in and we'll either do a really simple set of wills for the parents or a living trust. Some people want their own living trust. But then we create a separate freestanding special needs trust to go along with the will that we name in the will, but it's a separate document. And that's to catch any inheritance that your child might get from you. Because the last thing that you want is to get them on all these benefits and have them all set up, and then when you pass away, especially if you pass away unexpectedly when you're fairly young, they get this windfall of cash. They get, let's say, half your inheritance or half your estate if you have 2 children. Suddenly they're far too rich for their benefits, but they're going to spend down that inheritance quickly if they have a lot of costly services that they participate in. So rather than having them get kicked off of their benefits, you'd rather be able to preserve any inheritance you're going to leave for them in the right kind of trust. So the trust is there to catch their inheritance, and that's why we do it as part of estate planning. Another piece, another reason why we often create a freestanding document like that is so that it's not just created when you die. You can also start funding it while you're alive if you want to, or you can allow other people to use that trust to start giving money to your son or daughter. Let's say grandma and grandpa want to leave money in their will. They can name that same trust in their will for your child. They can give, write a check out to the name of the trust. Other friends, sometimes people do fundraisers, and everyone can write the check out to the name of the trust. So it can start catching money before you actually pass away. It can be revocable, meaning that if mom and dad if mom and dad put money into the trust while they're alive, sometimes there's an option to pull the money back out. If you set up the trust for your son or daughter, you get to choose who the trustee is. It's the person who's in charge. If you think you're going to start funding it while you're alive, we'll name mom and dad as the first trustees, but then you'll name backups, someone to take over when you can no longer be the trustee. And you also get to say where the remainder goes. That means that when your son or daughter passes away, if there's money still left in the trust, you can say where that remainder should go. Sometimes it's just to the other siblings, or to nieces or nephews or whoever you choose. Then there's some differences if we're talking about a first-party trust. Some reasons why your son or daughter might wind up coming into their own money is, let's say they get an inheritance that they didn't expect that wasn't properly sheltered, or they get a back lump sum of benefits, let's say from Social Security. They might have been getting the wrong amount for sometimes years, and suddenly Social Security realizes their mistake, and they send a check for several $1,000s, and then, oh, now you're too rich because of our mistake. You're too rich to keep getting your benefits. Or they get into a car accident and they win a lawsuit, or something like that. People do come into their own money family money, unfortunately, but there are these other first-party trusts that you can use to shelter the money. And you want to do that right away. If they come into their own money, you want to take care of it right away. That kind of a trust is irrevocable. So once the money is in the trust, it's in the trust. You can't pull it back out. And I'll tell you the difference now, which I said there were two different types of first-party trust. The first is a freestanding document that we can create for you. It's called Exception A because of the statute that it falls under. Like the other kind of trust, you get to choose the trustee. One difference between this kind of trust and the third-party trust we talked about is the Medicaid payback provision. And that means if there's money left in the trust when your child passes away, that money has to go to Medicaid. It's reimbursement for what Medicaid has paid out on their behalf over their lifetime. But of course the goal is to always spend all of it on the person while they're alive. But if it had quite a bit of money in it and they didn't have a lot of extra needs, there might be money left in it when you pass away. One difference too is that it needs to be set up by someone other than the person with a disability. So you do need to have a parent or guardian in the picture that can do the setting up of the trust. And there is another option if a person has their own money, and that's called a pooled trust. Dan actually, during his time that he worked for Hope Network, helped establish a pooled trust through Hope Network, and it's still running. And the difference with that kind of trust, it's actually a trust project. It's an umbrella trust rather than having your own individual freestanding trust. It's an umbrella. So Hope Network has already done the work of creating the master trust. And then there are separate trust accounts that fall underneath that. The benefit is that they are all invested together, so you should get a better return on your money because it's invested with so many other people's money. And then another thing that people often like is that it does not have a Medicaid payback provision. Instead, any remainder that's left when the person dies stays with Hope Network. So some people prefer that to the money going back to Medicaid. The person who has a disability can sign to join the pooled trust project themselves if they're able to do that. But Dan actually administers that trust project. He has a contract still with Hope, and so if you decide that that's something that you want to do, if your son or daughter comes into their own money and you want to join that pooled trust, you talk to Dan, and he would help you get signed up and then explain to you how you can have bills paid for out of the trust, and that's all handled by our office. So that's kind of the gist of special needs trusts, and Dan, I think, might cover guardianships quickly.
Yeah, we've got 5 or 6 minutes, which is about what we thought we would have for guardianship questions. You know, we can't do a legal presentation without questions coming up of who needs a guardian and how do you get it? Who doesn't need a guardian? How can you avoid it? Philosophically, there are people running around the state saying nobody ever needs a guardian, ever. And there are other people, like in certain special ed districts and other places, that say everybody needs a guardian if they have a developmental disability. You better get it by the time they're 18. And sometimes people say, oh, you better get it before they're 18. It takes a long time. You know, you better start working on it when they're 16 or whatever. And there's a lot of myths about that. Well, remember that a guardianship is a court order. It's not just somebody saying, I'm a parent, I've always worked with them and with my own son or daughter, and I'm going to keep doing it for as long as I live. And I'm the guardian, right? Well, no. A guardian is a court order. So there's 2 kinds of guardianships in Michigan. One is called a developmental disability guardianship, DD guardianship, and the other one is called a legally incapacitated individual guardianship, an LII guardianship. What's the difference? Well, you're mostly interested in DD guardianships because autism is a developmental disability. What's a developmental disability? It's a disability that starts before age 22 that has an effect on your major life functions. 5 major life functions. And it's a definition in the statute of what's a developmental disability. But autism, mild autism, where the person may not qualify for Social Security because they don't think it's severe enough, you could work. That may also be too mild to get a guardianship. You don't want to get a guardianship if it's mild or if they can handle their own affairs, even if there is clear diagnosis of autism. So it's a case-by-case analysis on who needs it and who doesn't. And I get a little frustrated with people that seem to be too black and white about it. There are people we've dealt with that are very severely impaired who do not need a guardian because they've gotten along just fine for a long time with social service supports in their life and natural supports from their family and natural supports from the community at large, and they just do fine without a guardianship. And there are other people that are higher functioning who are constantly getting in trouble because they're out and about, and they're signing contracts they shouldn't be signing, and they're buying cars they shouldn't be buying, where they need to have a guardian, even if they're higher functioning. So it's not just a matter of what the doctors or psychologists say, it's a matter of what their functioning capacity is like and where the dangers are. Some families want to jump automatically to the thing that everybody needs a guardian because what if? Very speculative, and parents are afraid, obviously. They don't want to see their son or daughter get taken advantage of. They say, what if somebody comes down the pike that's going to exploit their money out of them, or they're too vulnerable, too open to suggestibility, wasting their money, etc. I'm just going to get a guardian just to be safe. Well, we usually take a step back from that position and say, how real are those speculative fears? If they're just fears and there's no history of exploitation and there's no real known danger in the picture, why not start with a less restrictive option first? And then you can always move to the more restrictive court-ordered guardianship down the line if you have to. In fact, you can get a guardianship real fast if you have to as an expedited or emergency guardianship. So the process in a nutshell is when the person, obviously you cannot start too much before they're age 18 because you cannot have the guardianship hearing until they are 18. We've had some court hearings on the 18th birthday, but it's usually 1, 2, 3, 4 weeks after their birthday that you finally get in and get it scheduled, and then you have the hearing. So you start the process with a petition for guardianship on a DD guardianship. Now here's the thing that's the most time-consuming and the thing where you can rack up legal bills, unfortunately, and that is you have to have a psychologist do the right kind of report that's less than a year old and where the psychologist will come and be the witness at the court hearing. I'll repeat that. The same psychologist that does the report, in most cases, has to be at the guardianship hearing to testify for 10 minutes about their functioning capacity. And that's kind of a pain in the butt. When people were, in the good old days, before the, quote, budget crunches everywhere, the school psychologists would come and go to those hearings. And John Bryant with the Grand Rapids Public Schools, and I got to know many of the psychologists in this Kent County area who would do the right kind of report. It would be less than a year old. They'd come and be the hearing witness, and everything would go fairly smooth. There are the ways people get around this, and Hope Network is one agency, not just the only agency, but the DD agencies in Kent County have tried to learn how to play this game where they'll have a psychologist do the testing, but they'll have the social worker read that report, and the social worker will come to the hearing and be the witness for the agency. If the social worker is from the same agency as the psychologist, then they will let the social worker be the witness rather than the psychologist. But there's a lot of local practice and a lot of, you don't really know what the rules are. My general rule of thumb is, the bigger the county, the harder it is to get a guardianship, because it seems like most of the more rural counties around us here are easier to deal with and set these things more freely. In Grand Rapids, they set guardianship hearings, DD guardianships every Wednesday morning at 8:45. And however many people have petitioned the court for a guardianship, they'll set them in alphabetical order and just you sit there sometimes all morning waiting. If you've got a client with a Z, I'll say, you sure you don't want to change your name to Abraham? Because you'll sit there all day waiting for the next for you to come up in alphabetical order. But that's how they do it. So there's another little thing on a DD guardianship. The psychologist has to do the report, and there's a separate court form called a report to accompany petition that they have to fill out. You also have to get a statement from the physician, like the pediatrician that they always had, documenting the developmental disability and any other physical needs that they have. It's usually a one-page form. They've condensed that down to just a one-page form. But the DD statute has, in the mental health code actually, has a special provision where everybody who's petitioned to have a guardianship appointed over them needs to get their own attorney. And they call it the attorney for the ward, proposed ward. And so what they do to try to make that workable is they've got a cadre of 5 or 6 attorneys who are on rotation at the probate court to be appointed to be the attorney for the person with a disability. Almost always they just meet that person for the first time at the hearing. And they go through the motions of asking them, is it okay if your mom's your guardian? Or do you want to fight this, basically, is what they're asking. You know, do you want to have a guardian, or do you not want to have a guardian? Do you want somebody else to be your guardian? That attorney is there and legally obligated to help them articulate their wishes at the hearing, even if it's hard to do, even if they're not verbal. I mean, if somebody just is completely behaviorally out of whack that day, and everybody says it's because they know that there's going to be a guardian, they do not want that person to be their guardian. You know, it's the job of the attorney to help them articulate their objection and to actually then have a... So you go through that extra little step of having sometimes 2 attorneys in the courtroom. The attorney like us that helps petition the court, and then there'll be another attorney that's there on rotation for that day to represent the wards, and they'll go through the motions. It's a game. It's like a, but that's the way it works. Now, what are the alternatives to guardianship? The first and most important one is a power of attorney. And what's a power of attorney? That's more of a voluntary arrangement where the person with a disability has the cognitive capacity to say, yes, I would like to have my mom be my agent. I want her to keep helping me just like she always has. If they can form that intent, and they know roughly that they're asking their mom to help them with their banking and their applying for benefits and their filing of their tax returns and all that kind of stuff, healthcare decisions. If they know they want their parent to be that helper, then we'll err on the side of doing a power of attorney instead of a full-blown guardianship. And by and large, it works very well. I know that some of the judges have different standards for when a person should have the capacity to sign a power of attorney and when they don't. I've seen a lot of variation from judge to judge in West Michigan as to whether they think somebody has the capacity. But usually, if they sign it and it's working, it never gets before the judge. They don't have to rule on whether they have the capacity because the power of attorney is working. The bank is using it and letting the parent sign checks, and the doctor is looking at the power of attorney and allowing the parent to the agent to sign the release of information and the authorization for medical treatment. And, you know, powers of attorney, especially healthcare powers of attorney, protect the medical provider too, because it gives somebody the authority to handle that affair and sign those affairs and sign those releases, and that really protects the healthcare provider against liability as well, so they like it. So the vast majority of cases, powers of attorney work quite well if the person can sign voluntarily, knowing that roughly what they're signing. Now, when does a power of attorney not work very well? It's in the case of, say, bipolar disorder, where somebody's cycling up and down, where they decompensate, and when they're in a bad spot, they keep wanting to fire their agent. They don't like anything their mom is doing for them. They want to go to a different hospital. You know, that, if the power of attorney can be revoked at any time by the person with a disability. So it doesn't work very well if the person cycles and keeps wanting to revoke it. So it's, again, a case-by-case analysis of when it would work and when it wouldn't. There is one special form of power of attorney called a mental health power of attorney for people that have schizophrenia or other disabilities like that, where they know when they're in a good place that sometimes they decompensate and sometimes they're not in a good place. And they say in their power of attorney, when I'm in a good place, I want these services, I want this person to be my helper, and even if I tell you I want to fire them, because I know I've done that in the past, I've cycled that way before, don't believe me. I waive my right to revoke for at least 30 days, and it gets you over that rough spot, and it gives people more control when they are in a good place over their lives when they know they're not going to be in a good place. So that's an interesting concept of a mental health power of attorney that's not very widely used. Had hospitals in Grand Rapids say, what is this? Psych hospitals. Because they're not used to really dealing with them. It's a relatively new concept, but it's something that really is in the law and really can be a benefit to some people. Okay, so it's a little past 7:30. I'd be interested in both Sarah and I, and have at it. Any questions about public benefits or trusts or guardianship?
You mentioned the pickle amendment?
Yes.
Where, because my kids went from SSI to SSDI, and their benefits went way down. And you said that's not supposed to be like that?
They should not go down if their assets are below the $2,000 asset limit.
So who do I complain to?
Talk to Social Security about it. It could have fallen through the cracks.
Yeah. Okay.
Sometimes it happens.
Every once in a while you get through to a human being.
Yeah. Sir?
When you're talking about assets, I'm an older adult brain. Assets, I'm living with another individual for $710 a month. When you talk about assets, can we have a car?
Good question. There are certain broad categories that are not countable when they figure out your assets. One is your house, if it's your principal residence. The other is one car. The other is your personal property, your clothes, your computers, your iPads, or everything you own. Like that, it's tangible, personal property. A certain amount of life insurance, the cash value of a life insurance in general is countable, except $1,500 of cash value of life insurance doesn't count towards your $2,000. And a prepaid burial plan doesn't count. So a lot of times people, if they start getting too many assets, before they even start working on special needs trusts, they know they've got $10,000 too much, but they know that eventually they're going to have to line up some burial plan. A lot of times they'll take those excess assets and do a prepaid burial plan now, even while they're young, and get that taken care of. And that shelters the assets in something that's exempt, a certain amount of prepaid burial plan. The other thing that they do sometimes when they have excess assets is put it into an exempt asset. Do repairs on the car that are going to cost $1,000. Do repairs on the house that are going to cost $10,000. You can convert a countable asset to a non-countable asset by putting it into that exempt asset, those small things that are exempt. So there's a lot of planning along those lines.
My daughter is 26 and she's on her father's health insurance. When she is no longer eligible to be on his insurance, how does she get Medicaid, or how do you get Medicaid for her? And will that Medicaid cover community mental health services?
Okay, so the first question is, has she applied for SSI yet?
We did years ago and she was denied.
Okay, so we're not really sure why she might have been denied, if it was medical or financial at that point.
At that point, they thought she was too capable.
Okay, so it was a medical denial. So you can reapply for SSI and get the magic words from the psychologists into your reports. And then if you get on SSI, you automatically get on Medicaid. And Medicaid, you can be on Medicaid even if you're on private health insurance from a group plan. And they have an order of priority for what covers when. And it's always private insurance first, Medicare if you have it second, Medicaid if you have it last. So,
but what if she's denied SSI? Can she get Medicaid?
well, some people can. But again, you have to have a severe enough impairment to get a different form of Medicaid through the Department of Human Services. It's kind of, I talked a lot about what goes on behind the curtain at Social Security, and I didn't talk about what goes on behind the curtain at DHS, the Department of Human Services. There's 20 different Medicaid programs that they administer. And the easiest one is if you get on SSI, you get on full Medicaid, so you're happy. But there's different forms of Medicaid too, depending on all different factors, of the age of the kid and the income of the parents and the income of the person. So the thing to do is apply to DHS for a separate Medicaid, even if you're not on SSI yet, if it's a pretty severe impairment, which it probably is. So we could talk in more detail. But yes, that's one thing we do is help advise people about what to apply for when, especially in their background.
You alluded to this, I think, in one of your example about your client who worked at in the Meyer parking lot. But I just wanted to see if this was accurate. You can apply, an 18-year-old who is still attending high school can still apply and is eligible to receive Social Security benefits. Is that
SSI, you know.
okay?
If their parent isn't retired, they're not going to get Social Security disability, SSDI, but they could get SSI. So many, many children, even though they're still in school in special ed, apply at age 18 and start getting SSI at age 18.
Okay.
And that then is set by whether they're working or not. If they're not working, they'll get the full 710. If they are working, there's a special rule I didn't cover because it's too much detail, but they've relaxed the rules for young people that are working in a supportive employment job if they're still in school. In other words, you can make more than what I was talking about before if they're under age 22. And that's called a special student earned income exclusion. So yes, it's worth trying to work through supportive employment through school. Yeah.
My daughter is 25. She had SSI and Medicaid, and my husband retired, so it switched to SSDI, and she lost her Medicaid. Is that normal?
Well, here's a little trick or a little thing to think of. A lot of times, you know, the SSI has the automatic full Medicaid that goes with it. But say the parent retires and now they get a higher amount of SSDI and now they've got over the normal income limit for getting Medicaid. Sometimes they'll process it as a Medicaid spend-down case at the Department of Human Services where you have to incur a certain amount of medical bills each month before Medicaid picks up the rest. It becomes mostly for big catastrophic things down the line if you have that. But here's the thing to think about, is if the person has a disability from birth or it's a developmental disability with an onset prior to age 22, which somebody with autism is, sometimes they'll get thrown off Medicaid when they start getting SSDI in error. Because the computers are supposed to talk to each other. The computer at Social Security is supposed to talk to the computer at the Department of Human Services that they are a disabled adult child and they should stay on full Medicaid with no spend-down. And sometimes that just doesn't happen for whatever reason. It's human error or computer error, we don't know. But a lot of times I've been successful in just pointing out that they're a DAC, a disabled adult child of a wage earner who was on SSI and now is on SSDI because of the retirement of the parent. And they'll automatically put them in DAC status, which gives them back their full Medicaid without a spend-down. So that's something to explore. Yes?
Well, my kids got the SSDI, and they were still on Medicaid. When I talked to somebody at Social Security, said they would be get Medicaid for 2 years, and then after 2 years, they automatically get bumped to Medicare. Is that how that works, or is it?
Not exactly. It's true that there's a 24-month waiting period between the time you start getting SSDI and the time the Medicare, you know, Medicare is attached to Social Security, just like for our parents that are retired. They get Medicare at age 65 attached to their retirement. Well, for somebody who's even younger, if there's on SSDI, they get Medicare 24 months after they start getting SSDI. But they should, Medicaid is better, and you get many, many people get both. So I think it's inaccurate for that SSDI worker to say that it's Medicare instead of Medicaid, because you could still qualify for a form of Medicaid as a DAC especially, and then you get both, Medicare and Medicaid. And why is Medicaid more important than anything else?
Because you get community mental health.
Pays for community mental health services, your day programming and your supports coordination and your Hope Network services. Those are all Community Mental Health Network 180 services. They don't take Medicare for those things in most cases. I don't know if there's parts of your program that take Medicare, but in the general rule of the average client that's served through Hope Network, they just run on Medicaid mostly.
You just talked about a conversion. I just retired. We just talked about the conversion from SSI to SSDI, and it happened. My son would go to that. Does he have to maintain his $2,000 threshold?
Yes.
To qualify for that?
Yeah, absolutely. That's a good question. That reinforces how important it is. His assets in the bank, his bank accounts, his IRAs, his CDs, his savings accounts, his checking accounts, all of them put together cannot add up to more than $2,000. Otherwise, he's off his DAC Medicaid.
But he can own a car, correct?
But he can own a car, he can own a house, he can own a computer, he can own personal property.
Okay, so for SSDI, without Medicaid, you can have thousands of dollars in the bank, doesn't matter, because your SSDI won't,
That's
it's
right.
not dependent on assets, but the Medicaid is.
But almost everybody needs Medicaid if they have fairly high needs, autism.
You say assets in bank, so it's really, you're talking about cash or things in
Cash.
bank.
Assets under the pillow, under the mattress, under the
Okay,
rug.
but
I had a client in
cash.
Kalamazoo last year who had $20,000 in a box under his bed. And he's been humming along for a long time that way, but he called me up and said, do I have to tell him about this? Nobody knows about this. I said, yes, you have to tell him about this. This is a needs-based program. That's Medicaid fraud. You know, you cannot just play that game. The way to do it is to put that $20,000 in the right kind of trust, and that kind of segues into what Sarah said. What kind of trust would be the most important trust for somebody who's got $20,000 under the mattress?
The
First-party special needs trust. And they have two options for a first-party special needs trust. The first option is more individualized trust, and it has a Medicaid payback. And the second one is the Hope Network Pooled Trust, which doesn't have a Medicaid payback. I have one over here who's been waiting a while.
Hi, the power of attorney, you didn't really explain. I'm assuming that's not a court hearing. It's just processed paperwork, notarized, where, who needs to prepare it, how do you get it?
Okay, there's two powers of attorney under Michigan law. One is for general durable power of attorney. That's actually set out in the statute called EPIC, the Estates and Protected Individuals Code in Michigan. And that's for finances and applying for government benefits. And oh, by the way, Social Security is the only agency that is not on our powers of attorney. But you can get around it just by having the customer, your son, sign it on it where they need to sign it, even if it's a hand-over-hand signing. But everybody else honors special powers of attorney, durable powers of attorney. And then the other one is the healthcare power of attorney. And in Michigan, they say there's two things in the world you should not watch being made. One is sausage and the other is law. And the way they made the law for healthcare powers of attorney was very strange in Michigan. It was a very strong battle over living wills and right to life and all kinds of countervailing considerations. But they came up with a healthcare power of attorney or a patient advocate form. And that one, again, can be signed by the person. If it's the financial power of attorney can be drafted by almost any attorney, but don't just take stock language that's off the rack. You really should look at what that person is actually authorizing the agent to do. It should be somewhat of an individual inquiry. It's not as complicated as a guardianship, but it's not as simple as just going to OfficeMax and buying a power of attorney form. You could go to OfficeMax and buy a power of attorney form. Don't do it. Because, for example, in healthcare law, there's specific things that have to be mentioned in a power of attorney under the healthcare statutes in Michigan for it to be a healthcare power of attorney. And for this thing called a durable power of attorney, which will endure even if the person with a disability starts to decompensate or slip or not have as much mental capacity in the future, it stays as a durable, enduring document even if they're not capable to sign it in the future. But it only stays durable if you specifically mention the section of the statute that authorizes it to stay durable. So you want it to be a Michigan form. We do powers of attorney. Powers of attorney are not hard to do, but you do want to have some modicum of individuality when you decide whether that person has the authority just the capacity to sign it or not. And we just have a flat fee right now of $75 for powers of attorney. But I would say 99% of the people that come in for powers of attorney also want to do this special needs trust we talk about. So that's really, sometimes we'll do just the powers of attorney and then 3 years later do the trust package. Sometimes we'll just do it all right from the beginning as part of the.
So it never expires?
Right. If it never expired, you could have an expiration in the body of it, but mostly they're written to last indefinitely until the person may want to revoke it. Remember that person has the right to revoke at any time, unless it's one of these special mental health powers of attorney that has the waiver on the right to revoke. Lots of questions.
Retirement is when you start taking Social Security?
Yes.
Or, okay.
Yes.
And then the second one was, can anybody make a special needs trust fund, or does it have to only be the parent?
No.
Or can it be a brother or sister to make the special?
It can be anybody. We've had some cases where, the way families used to deal with these issues was sort of a homespun, practical approach. Disinherit the child with a disability, give it all to Susie and say, watch over Johnny. And then Susie would be sitting there with a double inheritance, not knowing exactly what they were supposed to do with that or how they should handle it. What if Susie gets hit by a truck and gets sued? Or what if Susie gets bankrupt? Or what if Susie gets divorced? And now all that money is gone, and you haven't protected it for the disabled child. It's a lot better to put it in a trust, and then it's protected from any lawsuits or anything like that, and you've got specific directions for Susie for what she should be doing with it. So the reason I bring that up is I've had many clients, even in the last year, where that was the case, where Susie got the double inheritance, and she knew it really wasn't her money. It really was supposed to be half for Johnny. And she doesn't like the idea of just sitting on that in her bank account. What if her husband goes to Tahiti with that money? So she creates, as a sibling, a third-party special needs trust now.
And there's no limit to how much you can put in that trust then?
Right. If it's got the right rules, that it's a discretionary spendthrift trust with total and absolute, lawyers put in legal ease into it to make it look legal so that people will honor it. That, sole and complete and unfettered discretion for the trustee. But it's basically, it has to have those rules in it so that those terms, so that it's not a countable asset. But it can be any amount of money in it. Because that trustee could take it all out and, they can't really spend it on other people. But if they don't have to give it to the person with a disability either. You got to really trust your trustee. Back here.
Yeah, one point of clarification and a question. The first beneficiary the person can be a beneficiary of both a third-party trust and a first-party trust,
yes.
Correct? Okay. Now, under the first-party trust, under freestanding exception A trust, how are taxes handled? And are there a couple of different ways how taxes can be handled? I read something about that. It's very confusing.
It's an extremely mucky area of the law. I always start out by saying I'm not a tax attorney. I don't pretend to be a tax attorney. I don't hold myself out to be a tax attorney. What I've been told is if it's an irrevocable freestanding exception A trust, it should get its own tax number and file its own tax return, which is a 1041 tax return for a trust. And it pays just like you as an individual pay income tax on the earnings from your bank accounts, that trust will pay income tax at a different, and it can be a rate that accelerates to a higher tax bracket faster with the trust too. But if it's a revocable third-party special needs trust funded by the parents, then I've seen it handled several different ways, but what I'm gathering is that the most common way is for the parent, if they're going to put their money in it at the beginning, and it could be revocable, they could take it back out or revoke that trust, then they associate their Social Security number with it when they open a bank account, and they get a 1099 on that interest to the parent, and the parent could tap that fund to help pay that share of the taxes due, but it's part of the parent's tax return. That's what I've been told.
So under the first scenario, where the taxes would be paid by the beneficiary or the trust, essentially is that person who right now, I have a child who's, I think, 19, he a dependent on my income tax return because he was now independent of me receiving his SSI?
My understanding is that the tax rules ask you to analyze what share of their support you're still providing. There is, I don't know if I can find it online, I probably can't. It's quite easy to find though. If you Google the ARC, A-R-C, Tax Guide 2013, I think it will come up. It's a wonderful little booklet on taxes for people with disabilities. And it's called the ARC Tax Guide. It's done by a guy I know in Oakland County named Tom Kinsorski. He's been doing it, updating it for 30 years. He stays on top of any changes in the tax law when it comes to disability issues, and he puts it all in a booklet, and he puts it out on the web free of charge. And so I would advise you to go to the ARC Tax Guide 2013. His name, well, I think I know how to spell his name, but it's Kinsorski. But it's not under his name, it's just under the ARC Tax Guide. Now that I think about it, it might be 2012, not 2013. Okay, let's go for 3 more questions, and then we'll take individual questions after that.
Can a special needs trust, either a first party or a third party, funded by SSDI or SSI funds to pay down to the 2,000?
Well, first of all, if you're on SSDI, you don't have to worry about sheltering funds, but if you're on Medicaid, you still have to worry about sheltering down funds. And could you take some of those SSDI funds and put them into a third-party special needs trust? The answer is, if it's SSDI coming in to the name of the child with a disability, even if you're a rep payee, it's their money, and it has to go into a first-party trust, not a third-party parent-funded trust.
But they could fund that out of there to keep the $2,000 balance down for Medicaid.
They could. They can't put money in a third-party trust, but they could put money in a first-party trust.
To keep their balance below 2,000.
Yes. Yes. And sometimes people will add, they'll just be very frugal people, and they'll, even though they're living on next to nothing, they keep bumping up against that $2,000 asset limit, so they'll write a $500 check, or their guardian will do it on their behalf, to put it into their first-party trust. We do a fair amount of that with the Hope Network Pool Trust, where people can add to their Hope Network Pool Trust account if it's first-party money, if it's from the person with a disability.
And Dan, Mom and Dad can put rent in.
Oh, yes. You want to throw in that? Okay. If the person with a disability child is living with you and paying you room and board, now it's your money. You can put that in a third-party trust, because now it's your money that you're putting in.
Okay, so
that child can't put it in
directly.
directly.
Rental charge, all right.
That becomes income for the parents, so.
It could, but I've been told that it's not a big tax consequence to the parents, because it's not all profit. There's expense to offset that income. Again, that's in the booklet, though.
Oh, good.
It's what they call the law and adversary.
One more question, and then we'll break up, and we can still take some individual questions. Any?
If we wish to provide an enhanced living situation for our son and SSI doesn't cover it, what's the best way to fund an enhanced living situation for housing?
Well, that's a more complicated question than you realize. Because a trust, if the person's on SSI, if a trust pays for food and shelter for the person, even part of their food and shelter, that's called in-kind support and maintenance, that causes you to get less SSI. And that's just a problem. So if people want to augment if they're on SSI, they want to augment the person's rent so they can get a better apartment, but then that makes their SSI go down by a third. They call it the 1/3 reduction rule. So that's a pain in the butt. So it depends on whether they're on SSI or SSDI on the answer to that question. It depends on if they're living alone or with other people. Sometimes you can tack together the rents, the income of 2 people on SSI and they can get what they call a Section 8 certificate together to help, where the government helps pay the rent, and that enhances the quality of the place. Those kinds of housing issues are near and dear to my heart, because that's what I did when I worked for Home Network, was this creative housing service. But I learned all the pitfalls of the different kinds of supportive living arrangements when I was doing that, and there needs to be a new clearinghouse of information, like at Home Network. I'll put in the plug. I think Home Network needs to do a new supportive housing arrangement, clearinghouse and technical assistance center on all these housing issues, because there's just families call us all the time, and they're just hurting for information on how to put this all together.
That website is the Art Michigan, to get the tax guide.
Okay.
Not just the Art.
Okay, thank you. Thank you. The Art Michigan Tax Guide.